The UK government just made a silent but very important change regarding when dependent children can get settlement in the UK. So stay tuned, let's go straight into the details. My name is Tochi, you're welcome to my channel. Please like this video, give it a thumbs up as you're watching so YouTube can recommend it to more people because it's very important. To all my returning subscribers, you guys are amazing. You're welcome back to today's video. If you're yet to subscribe, please click the subscribe button right now. Thank you. So guys, there's been lots of changes going on with the UK immigration, as we all already know. I'm sure everybody knows this by now. And recently, the government just released the statement of changes to the immigration rule. And in it was one particular change that a lot of people are not talking about. So I just want us to look at this because it's important for everybody to know what's going on. Like I always say, once you know exactly what's going on, once you stay updated, it will help you to make well-informed decisions, okay? Now guys, look at this. So now in this explanatory memorandum, like I explained in my previous video, whenever a statement of change is released, the government usually releases an explanatory memorandum together with it to explain better, giving us reasons why these changes are coming up and everything. Okay, it's just easier for us to understand this particular document. Okay, so here, if you've not seen the other changes, please watch it. The video is already on my channel where I just explain everything about the statement of change, the new rules that are coming up, when they're going to take effect and all of that. But this particular one is regarding children, okay, a dependent child when they can settle in the UK, right? Now, if you look at this, I just want to draw our attention to something, okay? But bear in mind that this is not an immigration advice and this does not replace an expert opinion. If you need one, do well to get one, right? This is just for information purpose. Now, looking at this document the government just released, you will see here clarifying the specific circumstances in which a child can be granted settlement to join a relative in the UK. Now, following the recent Court of Appeal case of Kone, is it Kone or Kone? I don't know. The Home Office is clarifying the policy on when a dependent child can settle in the UK under paragraphs 297 and 298 in part 8. Now, before we look at what the Home Office have now decided or what the new rule is, I think it's better for us to look at this Kone case and see what is all about that actually made the Home Office to now reference that case and now make a law from that case, okay, make a new rule from that case. Don't you think it's important for us to know exactly what the case is about or what happened in that particular case? So quickly, I want to tell you all about this great campaign that LemFi is running. Is for all users in Manchester. So if you are in Manchester, you stand a chance of winning £2,000. Imagine winning £2,000 in this economy. That's huge, right? All you have to do is send £500 or more, of course, on your LemFi app between the 4th of March and the 18th of March and stand a chance to win this money. That's all. So 3 lucky winners stand a chance to win £2,000 in total cash. Guys, this is great. So if you're in Manchester and you're a LemFi user, do this immediately. And if you're not even using LemFi yet or you don't know what it is an app that you can use to send money to your loved ones in Africa, and they have one of the best rates in the market. Okay, download the app, sign up with my code Tochi, and then begin to make your transactions. And if you send £500 or more between the 4th and 18th of March 2026, you stand a chance to win huge. So remember, the more you send, the more chances you have to win. Okay, winners will be selected via a qualifying draw and it's going to be very transparent. So good luck, everybody. Now, this is Kone or Kone versus Secretary of State. This is everything that happened, okay? But the summary of this case, when I looked at it, I'm still going to like point us to it, just show us bits here and there. But in summary, the case is about a young girl who was born in Ivory Coast and later came into the UK or wanted to apply to come into the UK and stay with her parents, right? Her father is already settled, but her mom is not. So she applied to be settled because her father already has a settled status, but the Home Office denied it, but instead gave her the same status as her mother, who has limited leave to remain. Okay, it refused to grant her settled status of her father, right? They also appealed and they won. Okay, they won the Home Office on this one. So that is exactly the summary of what this case is all about, but let's look at it in details. Okay, now the case arises from the refusal by the Secretary of State to grant the respondent, Ms. Kone Ile, as a child under paragraph 297. Instead, she was granted limited leave under Appendix FM on the basis of her mother's limited leave. So the upper tribunal granted judicial review and quashed the refusal. The Secretary of State appealed on 3 grounds. Right, so the Court of Appeal, giving the main judgment with Jackson LJ and Lewison LJ agreeing, dismissed the appeal. The decision is significant because it rejects the Home Office long asserted practice that a child joining 2 parents must always be given leave in line with the lesser immigration status of the parents. Like in this case, they gave the child the status of the mom because she had the lesser immigration status. She wasn't settled at the time. And also confirms that paragraph 297 is available to a child where at least one parent is present and settled in the UK, even if the other parent is in the UK with only limited leave. And finally, holds that the exclusion undesirable test is a normative assessment. The fact that the child has already been granted limited leave is irrelevant to whether exclusion will be undesirable. Okay, now this is the background. The respondent, Mrs. Kone, is an Ivorian national born on 16th of October 2002. Her father is a British citizen, present and settled in the UK. Her mother held limited leave to remain in the UK, right? So this is just the fact of the case. Okay, in 2015 she applied to join her father in the UK, and they accepted that her father was present and settled and her mother had limited leave, and found persuasive and powerful circumstances justifying her joining the family. However, the appeal was dismissed because she lacked a mandatory tuberculosis test certificate. Okay, now she went ahead to obtain the tuberculosis test certificate, and then she reapplied in 2018 for indefinite leave to enter for settlement under this same paragraph 297, naming her father, a British citizen, as her sponsor. 2019, she was refused, but was granted limited leave to enter until 26th of September 2021 under Appendix FM, which was tied to her mother's limited leave, and she entered the UK in July of that 2019. The judicial review was withdrawn on the basis that the Secretary of State would reconsider her application for settlement and issue a new decision. And then in October 2023, on reconsideration, the Secretary of State again refused under paragraph 297 but maintained limited leave, citing a policy of granting children leave in line with the parent who has the least leave. So the Home Office said that it's the parent who has the least leave, the least status. That's the same status the child is going to have. Remember that in this case, the father was already settled, a British citizen, but the mother was not. So she applied to get settlement just because her father is settled, but the Home Office refused, but instead gave her the same status as that of her mother. So the 3 grounds of appeal, the Secretary of State appealed this decision, the upper tribunal's decision, holding that the grant of entry, clearance or leave was not significant to deciding whether there was serious and compelling consideration, making exclusion undesirable. They also say that the upper tribunal misinterpreted that paragraph 8277B of the immigration rules, and that the upper tribunal also erred in holding that paragraph, which applies in circumstances where both parents are present in the UK. So after consideration, the Court of Appeal dismissed the Secretary of State's appeal, and its core conclusions were: 1, that this paragraph applies where at least one parent is present and settled in the UK, even if the other parent is also in the UK with limited leave. There is no implied requirement that only one parent be present in the UK, not that the other parent be outside the UK. Also, the requirement that there be serious and compelling family or other considerations which make exclusion of the child undesirable involves a normative question whether it would be undesirable if the child were excluded. The fact that the child has been granted limited leave and so will not currently be excluded is irrelevant. That the Upper Tribunal did misinterpret that paragraph because it applies to applications for leave to remain, not entry clearance or leave to enter. However, that error was immaterial to the outcome, you know. So the outcome of this case is that the court held that the Upper Tribunal was right to find the Secretary of State had misinterpreted that paragraph. The decision of 17th October 2023 refusing ILE under paragraph 297 was unlawful, and the appeal by the Secretary of State must be dismissed, leaving the Upper Tribunal's quashing order intact. So you can see that these people actually won this case. Okay, you can take your time and read it. It's online. Okay, if you just type Kone versus Secretary of State, you're going to see it everywhere. It's been reported and it's just everywhere online. So if you go through the case, read down, they try to establish or explain each phrase, you know, what they meant by indefinite leave to enter, limited leave, present, settled. You know, they try to explain what each meant in the context in which it was used, you know, so you understand the case better. I just wanted to summarize it for us to understand exactly what the case was all about and why they had to reference it or make a new law referencing it in the statement of change. So in conclusion here, Kone the Secretary of State for the Home Department is a significant clarification of children's rights under paragraph 297 of the immigration rules and an important check on administrative overreach within the Home Office. So that was exactly what this case was about. Now let's go back to this new rule that the government have just made. So it's now trying to clarify the specific circumstances in which a child can be granted settlement to join a relative in the UK. Now, following the recent Court of Appeal case of Kone that we just saw, the Home Office is clarifying the policy on when a dependent child can settle in the UK under that same paragraph 297 and 298 in part 8. So you see that if you don't read that case to understand what the case is all about, you might not truly understand or appreciate what this is all about. That was why we had to go back to read the case to understand it and know exactly what the government is telling us, you know. Now, the intention of the child settlement rules in part 8 is that a child should settle in the UK when both parents are settled or are British citizens. If only one parent is settled, the child can be granted settlement if that parent has sole responsibility. Example, the other parent is deceased or has abdicated responsibility, or there are compelling and compassionate circumstances. Okay, so can you see what the Home Office have now said now? So it now says that a child should settle in the UK when both parents are settled or are British citizens. So they've changed everything. So now they're now saying both parents has to be settled or British citizens before the child can be settled. And the only condition in which a child can be granted settlement if one parent is settled is that the parent proves that he or she has sole responsibility. Okay, that is if the other parent is deceased or if he had left his responsibility. Okay, or there are other compelling and compassionate circumstances. Now, I'm sure that it's left for the Home Office to decide what compelling and compassionate circumstances is in this situation because they didn't really tell us what makes up these compelling and compassionate circumstances. The reference to exclusion of the child has also been removed. Okay, paragraph 297 and paragraph 298 are also being amended to clarify that a child can join a close relative in the UK rather than any relative. A definition of close relative is provided in paragraph 6 of the immigration rules. So, looking at the definition of this close relative that the government just mentioned, it means a grandparent, brother, sister, step-parent, uncle, that is brother or half-brother of a child's parent, or aunt, sister or half-sister of a child's parent who is aged 18 or over. So this was what the Home Office referred to as close relative in this immigration rules or statement of change to the immigration rules. you know. So guys, that is it. I just thought to share, and I want to hear what you guys think about it in the comment section. That is it for today's video. Thank you everyone for watching. I'll see you guys in my next video. Bye bye.